Hello everyone, welcome back for this panel. My name is Greg Mounier. I'm working for Europol. I'm working for the Europol Innovation Lab. Before that, I've been working for the Cybercrime Center. And it is my pleasure this afternoon or this evening to be moderating this panel on artificial intelligence, big data and law enforcement. The rise of the machines. Hello everyone, welcome back for this panel. My name is Greg Mounier. I'm working... Sorry, I had some echoes. So we have about 30 minutes to delve into a super interesting topic. Unfortunately, we were supposed to have two other discussions on the panel. We were representing the law enforcement community. So if you agree, I will just take 2-3 minutes after I will have introduced the other panels to give the law enforcement perspective. I think they would have done it. And then I will give the floor to our two panelists. Our panelists are Tazin Khan. She's an American researcher and founder of a cyber collective, community-centered organizations that look into the intersection between tech, cybersecurity, and democracy. Taz is advising many Fortune 500 companies on security and data privacy, and she will provide us with views on AI use by law enforcement. And then we'll have later Stefano Fantin. Stefano is a PhD researcher on cyber law and security policy at the University of Leuven in Belgium. He's worked on the software vulnerabilities framework and encryptions, and he has had many research positions, in particular in a prominent think tank in Brussels. And he was also working at Europol in the data protection office as well as at the EDPS. But before we start with their position, I wanted to take a few minutes to summarize a little bit the law enforcement view on the use of artificial intelligence. As you know, one of the greatest technical challenges for the law enforcement community in this day and age is the information overload. Any investigations, in particular, of course, in the field of cybercrime, but in counter-terrorism, drug trafficking, nowadays we are processing a huge amount of information. You seize a phone and you have several gigabytes of text, of video footages, images, unstructured data that you need to process really quickly. And so it has become really, really important for us to have advanced intelligence system that can really help criminal analysts to do their analysis and process vast amount of information that are originating from many different sources. The main advantages of using artificial intelligence system is not only that you automate many processes that used to be traditionally done by people, basically. So it assists you in data management, it improves the compliance of the police. But the main added value of using that new technology is that it really supports the human analysis and the criminal intelligence analysis. We currently using in most of the law enforcement agencies around the world natural language processing modules. We're using audiovisual analysis modules. We're using text transcriptions or voice transcriptions. We're using AI to find patterns. We're using AI to better explore all the data that we have, and that would take a lot more time for manually process and identify correlations and connections. So there are many advantages for public security entities to use new technologies, and in particular artificial intelligence, in an era of big data. We could give you many examples on counter-terrorism investigations where suddenly investigators, right after the bomb went blast, have access to a lot of CCTV footages, they have access to communication logs, they have access to many different informations, and it's very important that they can really quickly sieve through everything to find patterns and take actions on the basis of that. There is another argument why the law enforcement community has to be able to use advanced tools to process all that information. And I think most of you have heard about a very recent report that Europol and the cybercrime sector has drafted together with our colleagues from Trend Micros and Unicry, called Adversarial AI. So in these reports that you can find online very easily, you will find a lot of very concrete examples of how adversaries, criminals, are using artificial intelligence to improve their capability to attack our system or to manipulate some aspect and to create scams. Of course, you've heard about AI, malware powered AI. You have heard maybe about social engineering with text very, very authentic being generated by AI modules, which automates the whole process of phishing. And then really briefly, the last main threats is deep fakes, of course. Manipulations of image and voice, which is very difficult for human and machine to identify, is leading a massive trend towards more disinformations, extortions, obstruction of justice. So it is another argument why the law enforcement community, we believe, should be able to, on an equal footing with its adversaries, be using advanced technology. But obviously, and that's also in a crowd like Eden, you're very aware of this, artificial intelligence used by law enforcement raises a number of very important legal, ethical, and social challenges. And these challenges need to be identified, need to be mitigated if we want to be able to use those systems and keep the trust and the support of the public and the society we serve. Of course, we can mention the AI black box problems, the fact that AI systems are not accountable. It's difficult to reproduce the decision they're making or they're proposing. And this is really undermining, this would have the potential to undermine the criminal justice system. And of course, the other big challenge is about biases. Biases will lead to discriminations, and they do lead to discriminations, and therefore they lead to inaccurate policing if we are working on data sets that are biased. So these are two of the main challenges that we have to address. But I think it is really important to keep in mind that in this day and age, broadly in the age of data, big data, it is very important for security services and the law enforcement community to be able to use advanced tools like artificial intelligence and others. So I will just stop here. I think I just gave the law enforcement perspective. And now I would probably invite Taz to give her perspective on this issue. Please, Taz, the floor is yours.
Thank you so much. I'm honored to be here. So thank you, Europol and the Eden Conference today for having me. Again, my name is Tazeen Khan. I go by Taz. I'm a cybersecurity specialist, a data privacy advocate, and the founder of Cyber Collective. And we're a research organization, and we are rooted in this kind of work, and I'm so excited to be here. So specific to some of the things that you said, I think that coming from the perspective of the Americans and a lot of what our government is inherently dealing with, and considering a lot of our history, there are many layers to this, right? So 100%, I agree that there is something beautiful that can happen with the use of big data and artificial intelligence, heuristics, and just this technology at large to help fight and aid so many, policing efforts that exist, counter-terrorism efforts that exist. It has been a tool that's been used on countless positive notes. The work that we're rooted in at Cyber Collective is kind of democratizing the way that this information reaches the people, and then also outlining how a lot of this technology is inherently biased. And the structure that our law enforcement lives on today is also inherently biased, right? I mean, the entire world knows that this year there was a continued effort to stop police brutality in the United States that specifically targeted Black and Brown people, marginalized communities. And with the way that the the concern around this implicit bias and racial profiling and the police transparency that currently exists, we can assume that the very nature of the big data collection presents a ton of inherent racial bias that already exists within our system today. And so our goal at Cyber Collective and the goal in our work is rooted in educating both sides, right? Consumers need to be aware of what's happening and what their role is, and understand our lack of data privacy that exists in the United States. We don't have any national or federal data privacy legislation. There are only 3 states in the United States that have any privacy legislation that exists, and most of these states are operating in a siloed effort. So there isn't a unified effort for consumer data protection. So you take the lack of data privacy, you take the kind of inherent system that exists and what the system was originally built on, and then you compile that with the way that this technology is being built and the potential for bias that exists. It leads to some murky waters and a lot of potential for both bad and good. So I think that in America, the conversation is just very, very different than the conversation that's happening in the EU right now because of our lack of consumer data privacy laws and because of a lot of the knowledge gaps that exist within society, and then also that exists within our government, I would say, and the perspective needs to widen. So the criminal justice system currently is definitely using a lot of different technology and resources to help and aid, but the policing technology is inherently biased. So that's where I'll put in my 2 cents for now. And I'm sure there will be questions, but that's my perspective. And the fact that there needs to be, 1, a federal legislation that exists within the United States that must happen. And 2, there needs to be more involvement of various communities in the development of this policy. And consumers need to be aware about how their data is being used and distributed and affecting their digital livelihood in addition to their physical livelihood as it relates to their privacy and physical safety for police brutality and racial profiling that exists today. So it's very nuanced in the States, very layered and very sensitive for both parties. So I try to tread lightly in the way that I approach the conversation. I have a lot of my own biases and personal opinions, but I'm going to try to speak as subjectively as possible today. But there's a lot of work to do. So I'm very, very excited to be here and learn from all of the interaction, and then also the rest of the panel here. So thank you.
Very much, Stas. Thanks for your input. Very interesting. Stefano, do you have a comment about what Taz was saying? Racial biases being inherent to the system, to AI. I think that you've done some really interesting research about the police handling requests for information. Please.
Yes, thank you, Greg. Thanks, everyone. Yeah, so we spoke very interestingly about biases, but I think the conversation about bias and how policy can change biases is not is just one piece of the puzzle. The other piece of the puzzle is how we need to ensure information rights and how citizens' rights are ensured not only in a commercial sphere, but most importantly in a criminal justice system. So this is exactly what we did in our research, and I'm happy to present you some more procedural and legal nuances of what we learned over the span of almost a year. normally, what legal scholars are puzzled with this AI in the criminal justice system is how we ensure explainability. Yet, what we did is saying, okay, let's take a step back. We know AI is being more and more implemented in law enforcement databases, so we need now to assess and stress test how information rights are handled to see what's the starting point. What's the starting point for compliance with data protection laws, and ultimately how citizen rights are enforced. Full disclosure, these are some findings I'm sharing with you. These are not complete. Some of them are being under review, have been accepted for a paper. I'm not naming and shaming here. I'm just making some examples. The research has been done over the span of a year. We coordinated with another team of researchers and many master students who joined the research. Altogether, we filed more than 80 subject access requests under two different legal systems. One is the Law Enforcement Directive, the other one is the PNR Directive. Basically, the Law Enforcement Directive regulates data processing, cross-border and internal data processing for policing purposes. PNR regulates the transfer of PNR data, so passengers' name records from airlines to passengers' information units at security authorities. What we wanted to see is how the exercise of the right to access works in practice. So what we did was conducting a very long legal research on how the laws were implemented in all the 11 member states that we selected. That was the first step. The second step we decided to do is, okay, let's see how transparency rights are there structured, and in order to do that, we looked into the websites of the police authorities, of the PIUs, to see whether all informations we wanted were there. After some desk research of this nature, the most interesting and exciting part was actually filing the requests. And again, we did more than 80 subject access requests. Starting from a basic thought, thinking that the right of access is not only a right that ensures a balance between security and police, law enforcement authorities, and the citizenship, but it's also an instrument for the exercise of further rights and the full enjoyment of both data protection rights and the right to effective remedies. I've heard during this afternoon speaking about the Schrems case. There's a whole line of thought, of doctrine in the Schrems case, speaking about the interrelation between the right of data protection and the right to effective remedies. So that was our starting point. We wanted to check many things. I'm gonna give you some examples, so you will understand the hurdles that we encountered while doing this research. Regarding the first initial request, under the Law Enforcement Directive, one of the most important issues we had was that a number of law enforcement authorities turned down our request because it was not done via regular mail. We all filed electronic mail requests, but some of them, even though they did not have advertised that all requests had to be done by a post mail, they dismissed that. They dismissed them, and they didn't even smoothen the transition between electronic and post mail. On a positive note, though, we observed that several countries provided pre-filled templates, which we were able to use and processed our request further. Another issue we faced was basically provided our proof of identity. We always provided our own passports. The problem was that some countries required us a proof of residence. proof of residence which could be supported by, I don't know, an utility bill or other proofs. The only problem is if I am a citizen of Italy, as I am, and I don't know, I've been to Spain and I have a legitimate request. I'm using Spain as a random example. I cannot prove I'm a resident over there. And after a few, in these cases, after a few back and forth, we managed to, in a smaller number of these cases, we managed to make our case, and the police authorities understood that this requirement was a little bit too narrow for the enjoyment of this right from the perspective of all European citizens. Let's look at the answers to our requests. What we were interested in was both time responses, so quality of the responses and the time of the responses. And the situation has been very, very diverse. So while some countries replied within the first couple of weeks, for instance, I see here some others instead went beyond even a month, or in some cases even reaching 6 months to answer us. There was even one case in which upfront the authority told us, "Look, you're not going to get an answer before a year." We regard instead to the quality of response. Well, we assumed and we were hoping that nobody was holding data about us, but it's not really this the point. We wanted to keep the request very broad in order to see how the police authority could narrow down the search. Against this test, some of our requests have been dismissed because they were deliberately too broad. Now, the law allows to do that, but we encountered a significant difference between some countries that dismissed it up front and some other countries who came back to us saying, "Can you please narrow down the research?" And within the countries who acted positively towards us, there were also some of them who, upfront in their templates, were actually asking to narrow down the search. I could go on and on. Another point, but that I want to mention, which was very important for us, was that there was one country that, instead of welcoming our and I'm talking now about PIU, instead of welcoming our request upfront, they redirected us to the National Supervisory Authority. Now, this is something that is allowed by the law, but the way we read the law and we read doctrine, we read it as a very restrictive, strict interpretation of this, meaning the citizen should be able to choose between a direct request, meaning filing it upfront to the national authority, or going through the Privacy Commission. Whereas this particular country, they didn't even give us the choice, and they said, "Oh, you need to go to the Privacy Commission. The Privacy Commission will then exercise that right of access for you, and in return you will get just an answer, yes or no, if the data about you is processed lawfully." I could go on and on, but I think I will stop here because we have limited time available ahead, and I would like to welcome questions. Just to conclude, I think we have. I'm looking forward to read the paper actually that we wrote and to disseminate it across the whole community, because I think this is there are very interesting findings therein, and it's been a very interesting year of experiment. I think the problems we've seen about a very except for a very few cases of clear mishandling of the requests was different and non-harmonized level playing field, which is of course because the legal frameworks we were investigating are directives, so they require interpretation by the national legislation, and thereby there are different levels of governance which are implemented there. But what we think is that this unharmonized level playing field creates legal uncertainty first, and sort of a chilling effect towards the citizens who want to exercise their rights in an European context, as opposed to a merely vertical and member state context. I'm going to stop here. I think I'm beyond time.
Thank you very much, Stefano. Thank you. That's very interesting. I have a question for Taz. You advising companies in their cybersecurity strategies and on data protection. If you have a client who wants to automate some of their processes, and everyone's talking about AI, and they find an AI open source modules that does a good job, what would be your first advice to them if you want to help them to minimize biases and therefore increase the accuracy of the output they would get from their tool?
My first piece of advice is always look at your team who's creating the technology and the algorithms. Is there diversity on that team? And making sure that the teams that are building these tools are as diverse as the tools need to be is always my first method and approach as I speak to folks, and recognizing bias. And as far as the any other type of implementation, right, like as it relates to compliance, I think that, again, I said this earlier, it's very layered, because I think that people in the States are still trying to recognize that there is inequality and bias that exists within these algorithms. And sometimes a lot of the people that I talk to don't believe that there is. They don't believe that there is inaccuracy that they have to check for, or a layer of diversity that they have to recognize and try to implement and be intentional about. So the conversations vary, but that's my first that's my first approach, is how diverse is your team? How diverse is their perspective in how they're building these tools? And then how is that perspective and how is that ethics, the element of ethics, being applied to the tools that you build, and really making it a Socratic seminar of questioning, and then allowing the team to come together to implement the approach based off of what's best for the organization, because obviously there's an element that is specific to each group, right? And to the work that these organizations are doing in smaller subsets.
That's very interesting. We have a number of questions from the floor. I'll take one from an unknown person who recognized himself. Very interesting, and that's for Stefano. How was your interaction with the DPO in the PIUs, or were you always referred directly to the national DPO?
Thanks for the question. This is very interesting. So the vast majority of the requests that we got back, the answers that we got back, or the answer with the requests that we filed, were to actual PIUs. So each PIU seemed to have a DPO. There were two exceptions. There were two countries which didn't even have an operational PIU. So one country was before the country didn't have the implementation of the directive ready, so the PIU was not yet operational. And I remind you, the investigation was beyond the time limit for the implementation. The other country, and that's the most interesting part, we tried to find information about the DPO of this PIU, but we couldn't find any. And at the end of the day, we filed a request to the air carrier, the national airline company, which told us, well, even if there is the directive implemented, there is no PIU operational, so there's not even a DPO over there.
Thanks very much. I will try to reach and bridge your research with the theme of the panel and AI in particular. And I was wondering, the PIUs, so the passenger name records units in each countries, they have to process millions of pieces of information every day, and they have to cross-check that information against a number of databases, criminal databases in particular, to make a decision. And so I was wondering whether sometimes the reluctance to answer your questions in the public access request was maybe related to the so-called black box problems, because probably they're using system that they might not really understand in terms of transparency and explainability of the system. Do you have any insight in this problem?
So I think that relates also the question from a panel, a person from the audience whom I'm a very fan of. We didn't even have the time to go that far to ask for automated decision making. We said, if we are trying also to investigate on that, we're going far beyond the year that we set up for ourselves. And even within the year, it's been so tiring and so long to having to bounce back and forth with these requests. So we didn't even have the time to make these questions, and it was already enough work for that.
Your next research paper.
Love to add to that also, that's a great question, and it brings up a really good point of like the cross-referencing, right, of the information that law enforcement holds, and specifically in America, and why I put such pressure on diversity and the inherent kind of biases in the system and the structure that exists in America. So, I mean, 13% of the Black Americans represent 13% of the United States population, but they comprise of 40% of the nation's incarcerated populace, right? And the legal system historically, I mean, there are 2.3 million people in state prisons, and think about that information and what the database that they're checking against, and the fact that the facial recognition algorithms right now, I mean, the inaccuracy in recognizing darker female and darker male faces versus people with lighter skin. I don't know off the top of my head, I believe it's a 35% inaccuracy. And so you take that information, you take the types of people that are being incarcerated and the information that law enforcement have, you think about the facial recognition tools that they're leveraging to continue to do their work, that's not recognizing a large group of people accurately. And then on top of that, there are no data privacy laws in the US exist to help protect the population from having their data being leveraged, and on top of that being wrongfully accused in our system. So I think that the point that you made in the cross-referencing and the amount of time and effort that it takes to do so, and then on top of it having already biased information that exists based off of historic elements, it is fascinating to me and a part of a lot of Cyber Collective's research as we continue this work.
Very much, Stas. I know we 2 minutes past the deadline, but I would like to finish with the concluding questions to both of the speakers. It is a question from Atina from the floor. Can we have a non-biased AI-driven system in societies that are wholly and partially biased? If you can take 5 to 10 seconds to answer, both of you, I would be glad.
I can let Stefano go first.
I'm a bit pessimist here, because I think a bias. Everyone in itself has a bias, and even if it's a positive bias, is a bias. So I really don't think so.
Agree. And I think that goes into larger conversations of ethics and philosophy that we would have to dive deep into. But unfortunately, no, I don't think that there is a way. But I think that there is continued research and people that are passionate about this that will do the work to make sure that we can get as close as possible. But at large, will it ever exist? I don't think so.
Thank you very much for this very interesting panel, both Stefano and Taz. Thank you for the time, and I will give back the floor to Jan or Daniel. Thank you very much for listening.
Bye.
Everyone, take care.